Today's lesson is on dolus and culpa, two of the elements that comes under aquilian actions. And if you haven't watched my video on aquilian action, please go back and watch it so that you will get a clear understanding of this lesson. As I have discussed in my previous lesson on aquilian action, a plaintiff has to prove three elements in order to establish a defendant's liability. These are a wrongful act committed by the defendant, pecuniary loss for the plaintiff, and fault on the part of the defendant. The first two elements I have discussed in the previous lesson, and in this lesson I will be discussing on the third element, which is fault on the part of the defendant. A defendant is said to be at fault if a plaintiff can prove both dolus and culpa. Dolus means wrongful intent and culpa means negligence. First of all, let's talk about dolus. Dolus in its wider sense means willful and conscious wrongdoing, and in order to prove dolus, a plaintiff has to establish three elements. Those are an intentional act, knowledge that the act will cause harm to the plaintiff, and finally duty to refrain from the act. We will get these three elements one by one and discuss in detail. An intentional act is an act whose consequences are foreseen and desired. This means if the defendant had foresight that certain consequences will follow from his act, and if he wishes for those consequences, working as a motive which induces the act, then he is said to have committed an intentional act. Also, you need to remember that there is a presumption in law whenever an act is voluntarily done with expectation that a consequence will follow. Law presumes that he intended all the natural consequences of the act. If I give you an example from my previous lesson on the law of delict, where I discussed the accident between Adam and Amy. When Adam drove negligently in high speed and knocked down Amy, the court will look into his intention and will bring about the presumption that he has acted voluntarily with the expectation that consequences will follow. Therefore, law will presume that he intended all the natural consequences of his act. In this way, the law will impute an intention to Adam which he did not in fact possess. This means even if Adam did not want to knock down Amy and he had no such ultimate objective, still he will be liable for an intentional act because he had the foresight of the consequences that would follow as a result of his act. I hope this point is clear with this example, and let's move on to the second element, which is knowledge that the act will cause harm to the plaintiff. The plaintiff can establish the second element if he can prove that the defendant had knowledge that his act will cause harm to the plaintiff. However, the defendant will escape liability if he can show that he bona fide and reasonably believed that his act will not harm anyone. In the case of Lawrence versus Smith, the defendant was held not liable to the plaintiff whose ostrich he had shot because in the circumstances the defendant reasonably believed that it was a wild bird and therefore the property of no one. So this clearly shows that the defendant can escape liability if he bona fide believed that his act will not injure or harm anyone. However, it is not a defense if the defendant knew that the act will cause harm to the plaintiff but bona fide believed that he was entitled to do so. Such a mistaken belief on reasonable grounds will not be a defense. The third element to be proved by the plaintiff is duty to refrain from the act. It is a universal obligation casted upon every person to refrain from intentionally and knowingly causing injury to the person or property of another without lawful justification. Therefore, there are no exceptions to this universal rule. However, in the case of Matthews versus Young, it was held that there is no onus upon the defendant defendant until the plaintiff proves that a right of his has been infringed. This means that the defendant will not be called upon to answer the plaintiff's case before the plaintiff has proved that one of his rights has been infringed by the defendant. Culpa or negligence is the second element a plaintiff has to prove to establish that a defendant is at fault. If a defendant has failed in given circumstances to exercise that degree of care which the circumstances demand, then he is held to be negligent. The case of Blith vs. Birmingham Waterworks Company defines negligence as the omission to do something which a reasonable man would do and doing something which a reasonable man would not do. Therefore, this negligence is a relative but not an absolute conception. Always the court will look into the point of view of a reasonable man to determine whether the defendant is negligent or not. Also, you need to remember that there is no liability for negligence unless there is a legal duty to use care. Also, there is a test adopted by courts to determine the circumstances in which a duty of care arises. This is called the foreseeability test. Through this test, court will determine whether a reasonable man would have foreseen the likelihood of harm and governed his conduct accordingly. However, as heard in the case of Cape Town Municipality vs. Payne, this will be determined on a case-by-case basis. So if we take the case of Adam and Amy, the court will determine whether a reasonable person in the position of Adam would have foreseen the likelihood of harm and governed his conduct to prevent such an accident. I hope you got a clear idea as to what is dolus and culpa. If you still have any doubts or need further clarifications, please comment in the comment section. Thank you.